Good morning. I'm Tom Martin. I'm your host today. The panel that we have is a fantastic panel of Access to Justice geniuses. It's our Access to Justice Genius panel for the American Legal Technology Awards. And just to plug that a little bit at the beginning, the American Legal Technology Awards is going to happen on October 6th. It's going to be an in-person awards dinner gala in Austin, Texas. It's going to be held at the Bar Mansion, which is just outside of Austin. We'll have shuttle service. It's going to be amazing. It's a very beautiful place. It is, in fact, a mansion. And there's going to be live live entertainment and a lot of fun. So I really hope you could join us there. But if you know of anyone who is making a difference in legal innovation, and there's 10 different categories, so please check out americanlegaltechnology.com to learn more about the different categories. But if you know of anyone, and if it might be you, please submit your nomination at americanlegaltechnology.com. We'd love to learn more about what you're doing and recognize you amongst the community so that, you'll keep doing good stuff. We've been around, this is our 5th year, if you can believe that. And we're very excited to see who the up-and-comers are now. So americanlegaltechnology.com. The panel today is to discuss access to justice, and I'm very, very proud to be joined by our panelist. Maya Markovich is the executive director of the Justice Technology Association, or Justice Tech Association. Natalie Anne Knowlton is the founder of Access to Justice Ventures and newly appointed as a special projects advisor to the Deborah L. Rhode Center on the Legal Profession. And we also have Quinten Steenhuis. I hope I'm pronouncing that correct. Co-director of Legal Innovation Technology Lab at Suffolk University Law School and founder at Lemma Legal. So that's kind of like the thumbnail sketch, but I did ask each of them to introduce themselves and talk a little bit more about maybe something they've done recently and talk about the role that they have, because I know a lot of us, when we think about access to justice, it might be a more narrow view of it as, legal aid or just like, people that have low income that qualify for some additional services. And as we all know, the facts and figures that we talk about every single year, people need help and people are underserved. And that's all stuff that we rehash every year. So we don't need to go into that in depth, but I would like them to talk about what they do because they come from each very unique points of view. So Maya, start with you.
Sure, happy to get going with this amazing group. I love you all. I'm glad we're innovation and justice warriors. So yeah, I'm happy to introduce myself. I am not only the executive director of JTA, but also Village Capital's entrepreneur in residence in justice tech. And so with both those roles, I have the lens of supporting early stage tech startups through JTA. So JTA is a nonprofit trade group that supports these entrepreneurs that are building tech to bridge the access to justice gap for people who can't afford or don't want attorney services in the legal issue that they're facing. So we provide early stage support to those founders because they're often from underrepresented groups. They're farthest from the resources and connections, and often they have lived experience with the problem they're trying to solve. So they have the best ideas. So one project we're working on right now is supporting the Legal Aid of North Carolina Innovation Lab on ways to vet potential collaborations with tech providers for those potential clients who are turned away for one reason or another from gaining representation through LANC itself. We're also working on a number of different and innovative ways to support our founders all the time. I'm going to get into more of that later.
Great. Thank you, Maya. Quinten, how about you?
Hi, yeah, I'm Quinten Steenhuis. I work at Suffolk University Law School in the Legal Innovation Technology Lab, where I'm the co-director of that lab. David Colarusso was the founder, started it a couple of years ago. And in the lab, what we really try to do is to focus on building things. My co-director, David, likes to say that we work on building the roads, so infrastructure, things that will help enable and empower other folks to help solve access to justice problems at scale is really our sweet spot. Some of our big areas of work are document automation. We built a website called courtformsonline.org during the pandemic. That involved volunteers from all over the world who were looking for something to do during the pandemic. They joined our group to help build tools and to build court forms that were interactive that could help solve the justice needs of people in Massachusetts during the pandemic when they couldn't get help in person. Another area of work for us that's been a long-standing one is artificial intelligence. We're rounding that out now with looking at ways to integrate generative AI, both into document automation and to other parts of the justice workflow. We've also been specializing in e-filing for the last few years. So Suffolk Law School, our Lit Lab, is as far as I know, the only nonprofit certified third-party filer for the Tyler Technologies platform. We're building a platform agnostic e-filing service provider. We're looking to add other vendors as well to our stack. And what we're really focusing on with our platform and why we think it was necessary to build a third-party EFSP is to enable people, when they get to the end of a really nice, easy to use, guided pathway to help solve a legal problem. Well, what do? You have to print that document, you have to bring it to the court, or maybe you have to navigate one of the first-party e-filing platforms, which are very challenging even for attorneys to use correctly. You get tons of clerk projections, people have to come back and start over, they make mistakes. So what we're trying to do is integrate the process of using a guided pathway with e-filing so people have a one-click and very seamless experience. That's really the niche for our e-filing provider platform. And what's kind of exciting is that we're building that out across multiple states right now. So we're working with 2 courts in Massachusetts, the trial court, which spans all of the first level trial courts in Massachusetts, and also the appellate level court. And we're also working in Illinois. And we have funding from the State Justice Initiative to expand that work across the whole country. So we're looking for partners right now. So if you're interested, if you think that especially pro se, unrepresented e-filing is a challenge in your state, that's an area where we're actively looking to expand to more states and serve more people. The work that we've done with document automation is already actively being adopted across the country. So we work regularly with 8 states. We have weekly meetings. We talk through how our platform could help them with the document automation, simplify it. We build new features based on the requests and feedback that we get from the participants in our project. And we build our own forms out for Massachusetts and for, in some cases, in partnership with other states too. So that's a little bit of a slice of what we're doing now and what we hope to do over the next couple of years.
That's really awesome. I love that it's solving that last mile issue, which is really important to get it into the court, not just the document automation, but that's really cool. Natalie, I'd love to hear more about what you're doing and your new role.
Sure. I'm Natalie Knowlton. I'm the founder of Access to Justice Ventures and the principal consultant there. And what we're focused on at A2J Ventures is helping entrepreneurs and lawyers or entrepreneur lawyers understand how they can work with legal technology and lawyers within the confines of existing regulatory rules. In some instances, that means helping entrepreneurs through the Arizona Alternative Business Structure License application, or telling entrepreneurs about the Utah Regulatory Sandbox, which allows for some flexibility in unauthorized practice of law and corporate practice of law rules, but also working with nonprofits and for-profit companies outside of those 2 states who are just trying to understand how to bring legal services into other relevant legal tangential services to make it a more seamless experience, kind of a one-stop shop approach for their clients, whether they're for-profit clients or nonprofit clients. As you alluded to, I did just start as the special projects advisor, they're all special projects, at the Deborah L. Rhode Center on the Legal Profession at Stanford Law School. So I'm very excited to be there. More to come on some of the work that I will get into there. Before all of this, the last few years, before that, I spent a very long time at the Institute for the Advancement of the American Legal System at the University of Denver, working in family court simplification and family court reform, working on civil court reform and civil court simplification, studying self-represented litigants. I know that Quinten has done so much of that work, and it's been really instrumental in how we understand the experience of people going through the legal system without a lawyer. So I've done some looking at that as well. And then at ILS, I also worked on advocacy on regulatory reform around the country. So very excited to be here today with you all and honored to be on this panel.
Well, thank you all so much for that. I think all of you can definitely see now that, you know, A to J is not what it used to be. It's expanded quite a bit, and that's a great thing, because the more that we can expand our thinking of what it is, I think the more that we could actually expand access to justice. So with that, I do want to jump into some of the topics that we have. The first one, just want to get it out of the way, because, you know, AI is everywhere all the time, on everybody's mind. And, you know, is it going to take our jobs? Is it going to do this? Is it going to eliminate the access to justice problem? What I'd like to ask each of you is, are there any concrete, like, non-hyped actual examples of the use of AI that you've seen practically applied within the past year and a half since, you know, ChatGPT dropped? Is there anything like that you could point to where, hey, that's a pretty good idea and it's making a difference? How about you start, Natalie? Or
well, I'm kind of tempted to kick this over to Quinten because he's doing some actual work in this area. So why don't I follow, if that's okay?
Okay, yeah.
Hey, sure. Yeah, I can jump in. So yeah, we're putting AI to work in the lab. I will say that we're starting with the safest use cases first. So one really long-standing tool that we developed at the lab, actually before I joined, it's called Spot. We did that in collaboration with Stanford. And it's a classifier. It just lets people describe their problem in their own words, and it helps figure out if you've tagged it, what legal topic does that have in that question. And you can tag resources, you can tag these guided interviews that we build with those same classifications, and then you can link people to the right thing. So triage and helping people find the right resource for their problem is one place where I think AI can be used really safely. You're helping get people further down the tree. They don't have to pick their problem out of a long menu. And that first version is using just plain machine learning. And we're experimenting with ways to add generative AI into that. And I think this is going to help solve a real big problem for legal aid organizations that need to do intake. For example, they often have new grants over the course of a year. Maybe the rules for what cases they can take are changing a dozen times. Doesn't sound that bad. But if you wanted to build an online experience that helps guide someone to understanding if their case type is being accepted, rather than having to pay for a call center employee to give that same information and have them wait in a queue to talk to a call center employee, hard coding those rules and maintaining and updating them 12 times a year is really burdensome. So I'm working right now with Legal Services of Eastern Missouri, where in my consulting role, I'm helping them try to solve that problem with generative AI. It's not live yet, but actually it's working really well so far as we're testing it. So I think that's a use case that we're going to see expand over the next couple of years. Another place that we're using it is to help us build things more quickly. So we're integrating generative AI into our form building tool that we use for document automation. It helps create a first draft of the tool. Then we can take that first draft, we can customize it, we can have it get sent to subject matter experts to review it and make sure everything is correct, and check all the logic. It's saving us a lot of time, but the end user the self-represented litigant never has to deal with the risks of the generative AI making a mistake because everything is checked by a lawyer before someone sees it. I think those kind of use cases where you're helping people kind of sort through information and drill down to the right thing, where you're giving the tool to builders, people who are lawyers, whatever their role is that's in the justice system, helping make their work more efficient. Those are the first safest use cases. And I think that's where we're going to see the most success, because it's really exciting how close generative AI can get to what we need. I think the reality is it's at like 80% success. That's good enough for lots of things, but maybe you don't want to give an 80% accurate lawyer directly to a litigant to use right now.
I agree. I think so from the Justice Tech founders and those products perspectives, I will say that I'm hearing a lot from them about the kinds of, they're implementing AI to improve their existing products, of course. And a lot of them have implemented it and are in listening mode almost. They're watching how their users are interacting with it and how they're figuring out how to fine tune, how to go more quickly to where the problems are. I think, there's been a huge surge of B2C legal tech companies. Of course, many of them are mission focused since the market demand is huge. And I think AI has the potential to level the playing field when it comes to performing, things like what Quinten was saying. So performing simple legal tasks, increasing consumer protection, helping them, translate contracts, confidentiality provisions, terms of service, and areas of law where getting information about process to those who are representing themselves can have a big positive impact. I think and as Quinten mentioned also, it can also really help legal aid organizations scale up the number of folks that are seeking help from them. But I think also AI is still software. It's made of code that's written by humans, and you get out of it what you put in. And these technologies need to be built from the ground up to identify and reduce those inequities that are built into our justice system. If we do all that, it can absolutely improve access to justice. That's where we're heading.
And I'm hearing a lot of interest and some use from courts on the self-help front, because for courts, the legal information component is critical for all of those who go through the system and don't have a lawyer. So we're hearing people talk about creating new information or reducing the complexity of existing information, taking information and putting it into different modalities so that you can have images and videos from simple text. And I think that's where I see the most excitement from the self-help court front. And also legal aid is doing some of that work as well.
Yeah, it's really fascinating. Quinten, like what you mentioned, I think a lot of people have that misunderstanding, right? That when you talk about generative AI, that it's only generative, like it's only pushing stuff out. And, we've seen plenty of examples of write a poem in the tone of what have you and all that, interesting stuff. But it's very good at analysis and extracting information. And as you pointed out, so many, like, what is the number one thing that clients want to do when they come to us? They want to tell their story, right? And for lawyers, mostly the story is a messy thing to deal with. But you could actually use AI to go through that story and extract the important information, at least from a legal standpoint. And yeah, so really, really cool. I guess just related to that, what do you all think of any concerns or like challenges that come up with using generative AI? And we kind of hinted at that. And of course, there's the big discussion about hallucinations, but are there any other kind of secondary effects that we should think about in using it for access to justice purposes? Quinten, how about you tee us off for that?
Well, so I'm thinking about it from the perspective of a builder. And I think one challenge there is anyone can go to ChatGPT and start typing stuff, right? And you get back something. I think where there's that missing messy middle where you have to translate the text you can get back from ChatGPT into actually doing something useful for you. And we're seeing this start to happen. So Microsoft has released a tool that takes a Word document and turns it into a PowerPoint. We're doing something similar where you take a Word document or a PDF and you turn it into a guided pathway. It's a draft. You start and you edit it, right? But it took a while for even Microsoft with all their resources to be able to release that. And I think we're going to see lots of places where AI could be useful. People have to do that integration work and write the code, maybe with the help of AI, but it's not doing all of it unguided. You have to tell it what code you want to write and review it and test it and get the bugs fixed. And actually to make it do something useful, because just only the text is not usually what we want. We want it in our other products where we're actually working every day.
What do you think, Maya? Have you seen anything where it's presented some potential difficulties that you think other people might not be tracking right now?
No, I think very smart people are actually tracking it. And I think, especially, I know about the work that Margaret Hagan is doing at the Stanford Legal Design Lab, where, her group is getting in front of the tech companies themselves and attempting to provide them with feedback on the accuracy of the results that their products are providing. And I think we need benchmarks. And I think that, it's a huge endeavor, but if anyone can do it, they can. And I think we need to establish a couple of things, right? There's that, of course, and I think actually even more broadly and at the same time, core to the whole thing is that we need to have a situation in which people are all on board, even if it's in particular silos, with the need for generative AI to provide benefit to all of the consumers. And for that to be the reason why we're doing this development. And not just to, not to increase the chasm of the access to justice gap, and increase the difference between people who can access expensive technology and those that can't. So, that's, I don't mean to be vague, but I really think we're in early days yet. And I think we still need to do a lot of work in messaging out that this is an opportunity to do good.
Totally agree. What do you think, Natalie?
So I'm glad you mentioned benchmarks, Maya, because I was going to talk about that as well. And I'll build on what Maya said about the need for benchmarks and accuracy measures. And I'll just give a shout out to Screens AI that published recently their accuracy metrics, which I think is hopefully the first of a lot of companies that do that. But when we're talking about accuracy of these systems and these tools, compared to what? So we're talking about compared to humans, and the legal profession has really done a poor job of measuring what it means to be an accurate lawyer, what it means to be an effective lawyer. And so as we go and go further into this benchmarking, which is critical, if we're going to be able to use and trust these tools, we're going to have to understand what exists on the human side. Quinten commented, well, we don't want to give an 80% successful lawyer tool to a litigant, but what if the human is only 70% successful? So I think we need to understand this a bit more. And I think lawyers are really going to push back on that because law is kind of a credence good. Consumers are not entirely sure what they're getting. They just get something and they really can't tell what the quality is. I think that becomes particularly hard when we talk about AI in courts and judicial decision making. We know that judges are biased because they're humans and humans are biased. I think AI has a lot of potential for sussing out some of the biases and potentially reducing biases in the system. But how do we go about measuring bias in judges and court decision making? And how do we reconcile what is bias and what is judicial discretion? So I think one of the biggest challenges in the legal industry we have is just this lack of human benchmarking. And you're seeing some of this come out in the medical field. They're doing some benchmarking, and you're seeing some benchmarking against AI and humans in some other areas like summarization. But I think we need a lot more of that really specific to legal services providers and courts.
Those are fantastic points. I think that the benchmarking and bias are definitely like under reviewed by people, or not as much on people's radar. But the benchmarking now is definitely going to become a thing, hopefully, where it's not just internal benchmarking where one company is saying this is our accuracy rate, but there's actually something to compare it against. That couldn't come soon enough. So, but I think that, yeah, you're right. It does beg the question about attorney benchmarking. There's going to be a lot of resistance to that. But the thing is, it's actually necessary, right? To know like how the AI is functioning in comparison to that. You can't do that without that standard. And the bias, one thing about that I think people don't aren't aware of as much is that the bias is somehow produced by the machine, but the bias is actually coming from us. You know, a lot of times
Right.
we point the finger at the machine, point the finger at AI, but it's only a reflection of us. And that's our historical data that it's trained on, which is what we generated. So we have to be careful what we do. But all of this leads to my next question, which has to do with regulation, but in particular, UPL. Because now that we're talking about applying AI in this context to help broaden people's use of legal services, there's always a question mark in the back of people's minds, like, is this crossing the line? Is this the unlawful practice of law? And there's, I think, some current litigation about whether or not it is, and whether or not that impinges on the First Amendment and issues like that. So with all of that teed up, I would love to hear, Maya, what you think.
Yeah, the short answer is yes. UPL restrictions are stifling innovation. People with a great concept from the technology side, with a great concept for a product that would go a long way to helping people access their rights. They might, not once they realize the regulatory roadblocks, and also once they potentially start seeking funding for their concept, they sometimes will run into some pretty significant resistance from folks that are risk averse when it comes to things that are under regulatory control. For the justice tech entrepreneurs that do dive in, it's a significant headwind. It's a total drain on their resources, and they can't help as many people. And I think you alluded to some of the great litigation that's going on right now. Some of those challenges were, recently laid out in the papers for the Upsolve suit, which is a nonprofit that helps people file for bankruptcy. And they, laid out things like, the vagueness of UPL and revenue sharing restrictions. Justice tech companies also, because of these restrictions, they can't hire lawyers directly to provide legal advice. It has to be within, with a very limited exception. Only law firms can collect fees directly from clients seeking legal advice. Otherwise, it's fee splitting, and that's prohibited in the US. Justice tech companies can't even hire paralegals with decades of experience to give any sort of public-facing advice to consumers unless they're supervised by a lawyer within a law firm structure. But what is allowed, however, is a lawyer fresh out of law school in an area of law that's supervising a paralegal within a firm structure to deliver the same advice. And it really just is not a client-centric system. So, these outmoded regulations are standing in the way of progress. The principles are incredibly important. There's no argument there whatsoever, but there are no clear standards, and it's really often treated like we know it when we'll see it, by bars that are often set up to protect lawyers' market share and not to protect the consumer. And they're right that it is very difficult to provide clear standards. But as it is, these vague regulations are stifling innovation across the board. And the bottom line is the need is so vast, and the opportunity is now. We need more clarity and flexibility so organizations can offer more of those solutions to consumers.
And Natalie, I know that you've also thought about this quite a bit, so I'd love to hear what your thoughts are.
Natalie's favorite subject.
Uncensored, by the way.
Well, good. I'm always uncensored on UPL. I think unauthorized practice of law, whether it's corporate unauthorized practice of law or UPL against individuals, is one of the greatest lies that the legal profession has told to new generations of legal professionals. We in the community are increasingly uncovering the real roots of where UPL came from. I highly recommend to everyone a paper by Professor Engstrom, Nora Freeman Engstrom at the Deborah Rhode Center. She and a co-author went through and dug up the historical archives in the big fight against auto clubs, which back in the day, AAA used to have lawyers for their members. In some instances, these lawyers would go to court for their members. But at the time, the early 1900s, the economy was challenging. We're coming into the Great Depression. The number of lawyers were increasing, competition was fierce, and this research team uncovered all of these archives of bar association meetings that show the reason that they decided to shut down these auto clubs, AAA and all the other auto clubs and all the other companies like this that were conducting corporate practice of law, was based on competition, not on consumer harm or consumer fear. So now that I've gotten that out of the way, yeah, we're seeing a lot of challenges to this traditional notion that UPL is necessary for consumer protection. But I say that because when we say unauthorized practice of law, people immediately go to, well, someone's going to have a serious divorce with child abuse and domestic violence implications, and they're going to go to a non-lawyer and get bad advice, and serious collateral consequences will emerge. But let me just illustrate to you that there are much smaller areas that we can have wins. Let's keep those kinds of cases in the lawyer's realm. Let's keep those in legal aid. But let me illustrate what UPL is now prohibiting in private practice, in market practice, and in courts. So determining a filing date. So a person walks into a courthouse and says to the clerk, I need to file this. And the clerk says, well, you have 14 days to do it. Well, what date is that? The clerk cannot then say, well, today is May 1st, and that means it's May, 14th, 15th. They cannot calculate those dates. They have to allow the litigant to calculate those dates using the rules and what counts as a business day and what counts as a not business day. Now, tell me technology can't do that very easily. Let's take another exception to the UPL rule called the Scrivener exception. And this is where a lot of legal tech companies are now operating, although this is very tricky. And under the Scrivener exception, you can, as a non-lawyer, write down exactly or capture exactly in writing what a litigant is putting into a form, but you cannot change it in any way. And I'm talking about adding periods. I'm talking about correcting misspellings. Quinten's research shows that there's a lot of bias that just comes with being self-represented in terms of how the system views you. And Quinten, please interrupt me if I'm not portraying your research in the correct way. But these types of clerical errors when people are typing into forms can be really, really influential on how the court is reading them. So just two small things there. There are plenty of other examples. When we talk about UPL reform, we're not talking about those incredibly high conflict cases and how they should go to a technology system and that's equal justice. We're talking about allowing some of these really restrictive rules to disappear so that people can have real practical benefits.
Wow. And thank you for sharing the history there. That's really eye-opening. I was unaware of that.
I will put a link to the paper in the chat.
Yeah, thank you. Natalie has the receipts. Quinten.
Yeah, I'll say that I think both Natalie and Maya, you've been working with entrepreneurs in the space and doing such deep work on this. You're totally the experts. I'm looking at it from a different point of view. So I've definitely had clients of mine as a private consultant who've been chilled by this. They're like, oh, we're going to build this thing together. And they're like, wait a second, I don't think that in my state I could release this.
Yeah.
We have a little bit of a safe harbor maybe when I'm doing nonprofit work and we're working with the courts particularly. It's not unauthorized if the court's approving the work that you do. It's authorized. That ultimately that tends to be where the regulation sits with the Supreme Court of a given state. But it seems to me that I think the big problem here is that our regulation is designed around this one-to-one service model that just doesn't make sense for what consumers want or what will actually be able to meet the needs at scale. Look, we know that the access to justice gap is something like 92% for people who are lower income. 92% of their problems are unmet by lawyers right now. There is no way that we can increase the number of lawyers to provide one-to-one service to each of those individuals and to get them the help that they need to be able to solve their problems in court. So we need to be thinking about other ways to help them. This is a metaphor I didn't create. I can't remember who to attribute it to, but it's like lawyers are stuck being cobblers, doing one shoe at a time for somebody. If we allow them to go to mass production, to build things at scale, people buy a lot more shoes today than they did 200 years ago before automation of that process. No one's looking to buy every pair of shoe that they buy in a year from a cobbler that has to hand stitch every part of that for them. They prefer the experience of going and buying a shoe off the rack. They line up around the block to buy the new latest Nike shoe, right? It's not that mass production is an inferior product necessarily. It can be much better to meet a particular person's needs, and it's what people prefer and what they're looking for. So we absolutely have to adapt these UPL restrictions to remove this cloud of uncertainty. And even where it's very clear, you can't do this, we have to change it, because the truth is these tools can be built in a way that they can be verified and vetted. They work the same way every time. How much better is that than a lawyer who passes the bar 30 years later? They haven't updated their information about the law, even if we think the bar exam was a great test. And there's no one checking their work every time that it goes out, right? It's much better to have these tools that can be automated to solve the simple problems that can be automated. And it's what the consumers are looking for.
I love the cobbler analogy. Like it's it's right on.
It really comes down to the need to refocus on the user centricity of legal services, and enable and scale alternatives that are supported by thoughtful, common sense, modern regulations.
Yeah, totally. Like if we actually think of it from the user standpoint, like from the person who actually needs it, then if that was a priority, all these things would be moving towards a solution as opposed to like a bit of a roadblock. So to riff a little bit on the UPL thing, like let's assume for the sake of argument that there's an alternative. Like what does that alternative look like? And I'll tee up something that I didn't think of at first, like it's been out there, but the idea of like if you move licensure to a corporate level where the corporation holds the license, you have everybody who can invest in and share in, the profitability of the company. You have experts in technology that are working as part of the company, and very likely, necessarily, you would have lawyers in the mix, but they wouldn't be in the same kind of structure they have now. Would something like that work, or something else, something different, something that any of you have thought of? Like, what are some alternatives to the current system that we have that might work? And I think I'll start with you, Maya.
Sure. I mean, there are dozens of brilliant alternatives that are really that have a lot of people working very hard behind each of them. I mean, obviously there's paraprofessional licensure, there's streamlining and enabling self-help in the courts. There's technology, which is where I sit. I think my opinion is there is no one approach. We all know that there's a big access to justice gap. We all need to row together in the same direction. Legal aid is doing amazing work. Pro bono is doing incredible work. They're overwhelmed and under-resourced. And so we need, new alternatives. And, we believe that tech canon should be part of the solution, but it could never be the entire solution. And I think one of the things we do at JTA, very proactively, is to create connections with and partnerships with organizations that are doing different kinds of work in the same direction, where we can be complementary to those kinds of efforts, and at the same time lift up all of the folks that are working towards it, and have it be a collective effort. So I think, my my most innovative idea is bring all the innovative approaches together.
Yeah, just hack at it in different directions and see what works.
Yeah.
How about you, Natalie?
I would second what Maya said about having an ecosystem approach. While each of us kind of work in our own niche areas, and to outsiders it might look like we're solely focused on this one solution, the reality is we're all operating in these areas as part of a bigger whole to see if we can affect change, how we can affect change, what works, what doesn't. We need experimentation on that front. So I think there are a lot of different ways that we can go about this. Court simplification, you have to look at the courts as well, not just the market. A different alternative legal services providers, whether that's technology or humans. But I'll also, put in a plug that there's only so much that we can do in the access to justice field, because so many of the access to justice problems, and I think it was Anna Carpenter and her co-authors in a law review article a couple of years ago pointed this out really articulately. A lot of the problems that are feeding into this access to justice crisis are bigger societal problems. So is it the responsibility of lawyers to solve poverty? Certainly we can help, but we're looking at real structural policies that are far beyond the purview of lawyers and legal regulators. So I think we're all doing the best we can, but I just want to acknowledge that there are other factors at play here. And if we want to move further upstream, I think we can start getting and chipping away at some of these issues. But it's really challenging because we have our particular expertise and our purview, and we specifically chose to be in the law, not to be in the legislature. So there's a lot of challenges, I think.
Quinten, is there a particular solution you're thinking of, or just all of them?
Yeah, no, I really like what both Natalie and Maya have already said, and I'll just say, I think that was the goal of legal aid, right? Like, and at least as it came about, what we see today, modern legal aid that came out of the Great Society, Lyndon Johnson, it was, hey, rich people are using law as a tool to improve their lives. We need to give that same tool to the poor. But actually, we've just seen the access to justice gap and continue to increase, and I think we could say safely that we're a much more unequal society too than we were during the Great Society movement in many ways. So whether it's a success and whether it is a tool that can succeed to do that, I don't know yet. But I think if we look at the regulatory space here, there's definitely some models that can keep litigants safe, that don't require one-to-one models of service. Why, we have engineers that they can do things. The plan has the stamp of approval. It doesn't necessarily mean that every step of the way that there's an engineer building everything. We could have models like that where somebody has to be involved in the process of building these tools that has the right certifications, and then that can flow down to the things that are built. That seems like a model that seems just so clearly could work here, and it should be just as safe, right? Especially because the tools work the same way every time. It's an interesting idea about maybe giving a stamp of approval to the firm too, and I'm not sure what that would look like, if it's a licensure for the firm or if it's something like maybe kind of some safety measures like inspections, whatever it might be, like we do right now in lots of different parts of the food system or other parts of the system where we're able to vet the work. And I've seen that the Underwriter Laboratory, I think, has an initiative right now to build some safety measures for generative AI. And I think that's something that could be interesting too, to have this kind of vetting of things before they're launched. Business ownership is kind of an interesting one to me because it seems like just obvious, like letting more people invest in this is going to spur innovation. But actually, that's true already in parts of Europe and the UK, right? And it's actually hasn't yet. So I'm curious to know why that isn't having that innovative effect right now. But it seems an easy win to say, yeah, why should it matter if you're a lawyer, if you own the firm that's building these things? That really shouldn't be the determinant of what's safe for the customer.
And Tom, if I can just build real quickly on something that Quinten said, when we're talking about kind of firm ownership and business structure, in a lot of instances, those are market-based solutions. And so market-based solutions are probably never going to solve the incredibly low-income, poor segment access to justice issues. that segment relies on subsidized legal services. Businesses rely on profit in order to succeed. So when we say access to justice, some of us tend to, or we think about access to justice as a bigger crisis, but we're actually segmenting out different populations and different groups who maybe can't afford, and there are different interventions that will work for each of those groups. So maybe the business structure is not the best approach for the subsidized services, but for Maya's JTA contingent, who are, maybe it's a lower profit, but they are for-profit companies, that might be more sustainable there.
Oh, that's a really good point.
Yeah, absolutely.
I agree with you. I think though that we're in a unique situation, right, where the scale of the solutions that are possible actually allow you to monetize much lower levels, but have the scale where you can actually be profitable. And it's just, one thing I just want to underline is I'm honestly excited about where we are right now. Like, I think that this is a unique time because we never before have actually had the tools to take this on. Like, we've had some tools, like, yes, there's been good old-fashioned AI with document automation and that stuff, but being able to put it all together, it feels like it's coming together and that we're reaching a critical mass point where things are gonna change. So about that, I'd like to switch gears a little bit and talk about your neck of the woods, the Justice Tech movement. Like, Justice Tech, okay, what is that? How is it different than A to J? Is it different? And what has driven its growth and the interest in it?
Mhm. Sure. Yeah. No, more specifically than what I've already thrown out there, I will say that, obviously, so Justice Tech is the tech side of access of this kind of one of the arrows to pointing at diminishing, and our North Star, of course, is ensuring access to justice for all, but in diminishing the access to justice gap through technology. We have the JTA now, we're only 2.5 years old, but we have almost 50 members. And they are all, virtually all for-profit organizations or PBCs that are building technology in a mission-focused way. We have a very, pretty stringent code of ethics that they need to abide by prioritizing consumer protection, mitigating consumer harm, ensuring consumer data privacy, and a whole host of other things we require. And so our view is that technology can and should be, as I said, part of the solution. What we're doing, and each of our members is addressing one area, at least initially. It's a nascent vertical. So while a lot of them are kind of trying to nail their first use case, or region of reach, and then from there planning to scale. And so that's where and also not only planning to scale their own offerings, but also scale in terms of the strategic partnerships, like I mentioned as well, with respect to partnering with legal aid organizations or umbrella organizations, partnering with courts, partnering with arbitration organizations, and also finding ways to capture the need that is not addressed by kind of this tip of the spear that everyone traditionally thinks of, either within legal aid or pro bono, and finding ways to support those folks with a tool that is consumer focused and in the hands of the consumer, and the consumer controls it, not necessarily something in our membership is specifically around technology that is more for consumers to manage themselves, rather than for to help, primarily to help with, for example, legal aid organization intake. That being said, there's so much potential for overlap, and all of these areas ultimately converge. And so we're seeing a lot of inbound demand on ways to collaborate with the platforms that are being built.
I think that's awesome. I also like the reframing, right? Because taking it from access to justice, as we have experienced it, to Justice Tech, really, enlarges the tent. And I guess
Yeah.
for Natalie and Quinten, like to the extent you think it's necessary to reframe this need and whether or not it's helpful, and if you have any other thoughts on how we might expand on that, Natalie.
Sure. And I apologize. It's, getting up there in temperature. So of course the internet around here dies at some degree outside.
It is
I do
temperature
think,
sensitive.
yeah, here it is. I do think it's important to reframe, and a couple of notes on reframing. So I think access to justice has for a long time been only thought of or respected as a low income, no income issue, but there are access issues all the way up the spectrum. And so I think that's an important reframing, because that also acknowledges that whether it's justice technology companies or lawyers, that there is a potential to have a real impact on access to justice and also feed your family and take care of yourself. Profit seems to be a bad word, except when we're talking about the private bar's ability to make money, and everybody thinks, well, that's okay. But I want the private bar, I want justice technology companies, I want them to be able to serve consumer segments that can pay something. I respect the fact that people need to make money in this industry. So I think that this profit seeking shouldn't be such a bad word when it comes to access to justice and justice tech. And I think part of that means having certain restrictions, certain ethical obligations, as Arizona has on entities for non-lawyers that are operating in this space, whatever it is to make us feel comfortable that for-profit actors are actually going to be operating in the best interests of clients, then I think we should be exploring that. So that's part of the reframing. And then one last thing I'll just say before passing it to Quinten, another part of the reframing is that it's justice technology or legal technology and lawyers. There are so many lawyer members in JTA. There are so many lawyer-led companies. There are so many lawyers who are working in this space. So it's an and solution, not an or solution. And to Maya's point about partnerships, it's really important for lawyers to start looking at JTA companies as allies and potential partners, even in profit. And conversely, it's important for JTA companies, and they are, of course, looking at lawyers as a way to impact more people in a way that I think is more palatable in terms of providing legal services directly, but then also providing a stamp of approval on some of the legal technology pieces that are coming out of their companies. So lots of reframing, I think, necessary.
Yeah, I'll take this chance to touch on something that Natalie raised earlier, just about the fact that there are a lot of market failures in this space. And I think that's something to think about on the government providing side, as well as from nonprofits. We have to figure out, where are those market failures? What are things that can only be provided for free or almost no cost, because that's the only thing that people are going to be able to pay. And we have to build metrics in that reward serving those needs. So one example, the Legal Services Corporation, I think, has done a fantastic job in the United States over the last 25 years of encouraging innovation in document automation and building lots of solutions that scale through their technology initiative grants. But at the end of the day, those build these one-off products. And from the legal aid perspective's point of view, they don't get credit for each person that they help. It's just kind of this amorphous number. They do get credit for each individual person that they meet with and provide one-on-one service. I think that's a disconnect there. And I think courts, there's some work to do there inside the court to help understand what their relationship is to the general public. Where does this neutral line fall where they can provide service to people to help them try to solve their problems? I will say sometimes when we get to the working with the court, they're not accountable directly to the people who are using the court system. They might be more accountable to the clerks and the people who are in the court environment directly. Maybe the lawyers, they might think of providing customer service to the lawyers, but not to the litigants who are trying to solve their problems. How can we figure out ways to align incentives there to help maybe get some of the innovation that we need to help close this problem? And some of the solutions can be very simple. They can involve, we can do all kinds of work to help automate around a really bad process that the court has. But if the court can just change their rules to simplify things, or work with the legislator to change the law that they're having to follow, you can help a lot of people, and they don't need the technology at all.
So to wrap it up, I want to give everyone an opportunity to give a final thought. And the final thought might be something about what you think might be one impactful step that the people watching this, our audience, can do to make a difference. Because we've all talked about it. That's great. Hopefully it's gotten everybody thinking about these concepts and reframing and how to do good in the world. But what's one thing that they could take away from this? I'll start with you, Natalie.
I would say venture out and read something that's different, either something that you maybe disagree with or something that you might not normally read about the access to justice problem, or even venture out and read something about a different industry that is solving a related issue that we're experiencing in the law, because I think there's a lot that we can learn by opening our minds to other perspectives within our industry, but also a ton that we can learn by looking at how other professions in particular are dealing with some of the same problems that we have, at least at a conceptual level.
How about you, Maya?
Yeah, sure. I mean, we, at JTA, first of all, I echo Natalie, and with respect to learning about other industries, because needless to say, at least on the tech side, investors are very interested in disrupting an antiquated system via technology. There's almost nothing more antiquated than the justice system. With respect to, we have a very concrete way at JTA for those that are interested in becoming involved and truly supporting the tip of the spear in technologies that are building building that bridge on the access to justice gap. We have, by popular demand, basically, we have a number of different pathways for folks to get involved. We have our brand new beautiful website, by the way, has a number of resources, and we're always adding to those, but that's been a good place for folks to start. In addition, we're always looking for strategic partnerships that will help us level up the impact that we can have and scale. So anything from law firms to mission-aligned organizations, to individuals, to volunteers. And that's a really interesting way as well, we hear, to get kind of an understanding of what's going on the ground right now. So not to end with a complete plug for JTA, but I encourage everybody to take a look at our site. We've got a lot of different ways for people to kind of learn more about the efforts and get involved.
And Quinten, you have the last word.
All right, saved by the bell, because it's hard to wrap this up quickly, but I will say I think that what I hope we see over the next year or 2 years is just tons and tons of experimentation. So I just encourage you to try. What can you build? What can you do with some of the generative AI tools like ChatGPT on your own? And then worry about the regulation part a little bit later. See what you can show it to a judge, show it to someone where it can be supervised by a lawyer. Just see what you can do, because I think there's a lot of potential, and we're going to have to experiment to be able to figure it out.
Yeah, forgiveness, not permission. But I want to thank all of you for presenting today. Thank you for educating and elevating all of our knowledge about access to justice. And I also want to personally thank all of you, because everyone watching, each and every panelist today is actually a judge too for the American Legal Technology Awards, and I'm very grateful that they're volunteering their time for that. And segue into, if you know of anyone who's actually doing good in the world with legal innovation and they certainly deserve to be recognized, please submit their nomination to americanlegaltechnology.com. And there's going to be a great gala dinner. It's the Oscars of Legal Innovation, October 6th in Austin, Texas. If you're going to the Clio Cloud Conference, it's going to happen right before that, so you're going to already be in town. I'd also like to thank our sponsor of our Access to Justice segment, which is ROG Legal Insurance. They're doing a lot to get affordable justice out there, so you should check them out too, roglegal.com. Thank you all so much for attending, and we'll see you next time. Bye.
Everybody.
Bye.
Thanks, everyone.